All right, so I've given you a little bit of an introduction to what I'll be talking about today in the morning tea. Okay, has that clicked through to another slide, Brad?
Yep, looks good.
We're in business. So the talk that I'm giving today is based on a paper that I co-authored that was published earlier this year with Brianna Collins, who is one of my research assistants. And this was some work that we did, what year is it now? 2020, towards the end of 2018 going into 2019. So around about the time that the Human Rights Act was being debated and passed by Queensland Parliament. And we started doing this thinking about how the Act could be used for climate change action. And we chose to focus on the right to life in this particular article, but I'll talk a little bit later about the Act and the various rights that have been enshrined. And I think there are lots of different opportunities for litigation under the Act beyond what we're looking at today. So before I get to the Human Rights Act, I thought it might be worthwhile talking about climate change litigation generally. I think some of you might be familiar with this. Some of you have probably been expert witnesses in these sorts of cases, and others of you probably aren't so familiar. So I thought we'd start from the beginning. So climate change litigation is a legal tool that has been used by concerned citizens all around the globe for probably the past 2 decades. And it's a really useful tool in circumstances where government action on climate change has been weak. And it can fill a regulatory gap. So where a citizen or an environmental group is unhappy with government action or inaction in the climate change space, they can bring proceedings before the court. And I'm sure a lot of you know Chris McGrath, who's quite involved with the centre as well. He gave a talk last year, and I remember him saying that one good thing about climate change litigation is that the doors to the courts are never closed. So within reason, excuse me, anybody can bring proceedings before a court and have their day in court and have their matter heard. Whereas you don't have similar rights to get something through the policy space or through Parliament. So that's one of the real advantages of being able to look at these things through the court process in situations where we're not getting the kind of legislative or policy action that we would like. So what cause of action does climate change litigation take then? The answer is many and varied. So in most jurisdictions where there has been a lot of climate change litigation, there's no specific statutory right to bring an action on climate change grounds. So for example, there's no requirement in legislation for government to specifically have regard to climate change in making a decision. So litigants have had to try and find other causes of action to frame their climate change arguments, which is really like environmental law 30 or 40 years ago. We didn't have specific environmental legislation, so litigants had to try and use other areas of law like negligence and nuisance to try and get their complaints before a court. So it's kind of an interesting parallel climate change litigation just 30 or 40 years later. So the diagram that I've got on screen now is one that was developed by Jackie Peel from the University of Melbourne and her co-author Harry Osowski, who do a lot of the work in climate change litigation. And they have defined climate change litigation really broadly using this concentric circle approach. They said that litigation can have climate change as a central issue or just as a peripheral issue. It might just be a motivation for bringing litigation, but not actually an issue. So something just on pure environmental grounds, for example. Or it might be something that really has no specific connection to climate change, but could have implications for it. So you can cast the net really quite broadly in terms of what's captured by the term climate change litigation. So this is a table of all climate change litigation from the United States, just to give you an example of the different causes of action that climate change litigation can take. And a lot of these won't be comparable in the Australian context. We don't have a lot of the same constitutional rights, for example, but you can see here that there's over a dozen different causes of action that litigants have used to mount climate change arguments. So you can be a little bit creative with climate change litigation, and certainly that's what we've seen lawyers do over the past few decades. You probably can't see too clearly, but the little grey numbers under the areas here show you the number of cases. So if you do a bit of a tally, there have been hundreds and hundreds of cases in the United States context, which is not surprising. The US is really the leader in litigation everywhere and a very litigious society as well. But a lot of the cases have come under federal environmental law, as well as state impact assessment law, and a few other things as well. So even though the US has been the leader, Australia actually ranks number 2 globally in terms of the number of climate change related cases that have been brought before the courts. So a report that was completed about a year ago now tallied about 94 climate change cases that had been decided in Australia. And I think would be up to 100 by now, just based on ones that I know about in the past year. So to date in Australia, the vast majority of climate change litigation has involved administrative challenges to government decisions to approve emissions intensive projects. So generally large coal mines or power stations as well, but mainly mines actually. So the cause of action, without getting too technical on the legal side of things, would be either a judicial or a merits review challenge to the approval. The table that I've got here on the screen now is one that I put together of the areas where I see climate change litigation certainly headed or heading in the future. So the one that I've circled in green here is, as I said, where we've seen the bulk of litigation to date. So it's mainly been state government approvals processes, although there have been probably about 3 or 4 examples brought under the EPBC Act as well, most recently in relation to the Adani mine. The other sectors are more where I see things heading into the future. So operators of emissions intensive industries, currently litigants have gone after governments rather than the operators. And the reason for that is that there are clear statutory avenues to challenge environmental approvals, although not specifically on climate change grounds. So it's just been a more, I suppose, low-hanging fruit option in that there is that specific right to challenge, although they've had to try and convince the courts to read climate change into the more general environmental considerations that are imposed there. But I think if this gets harder to do, and I'll talk a little bit about anti-regulatory action a little bit later, I think that environmental groups might start looking at the operators themselves, and we'll have to get a bit creative in terms of the course of action that they use there. Local government planning decisions. So this is something I've written a lot about in the past. So for example, where properties are affected by hazards like sea level rise and bushfires, we're going to start seeing actions against government entities in negligence in particular. And I think that will start to materialise in the next few decades. Similarly, property owners, so litigation around impacts from adjacent properties. So if somebody's built a seawall and that's impacting on erosion on another property, I think that's something that's going to happen. The 5th box here, this is one that I'm not too across. I certainly do not, nor do I ever want to be a corporate lawyer. But corporate law is going to be one of the really big spaces to watch for climate change action. So there was a report released in 2016 by Noel Hutley SC, who's one of the leading corporate law barristers in Victoria. And it was called the Hutley Opinion, and he released a revised opinion in 2019, where he was fairly equivocal that the duties of due care and diligence under the Corporations Act would extend to considering climate change. So the implication there is that if companies are not considering climate change in their day-to-day operations, they could well be liable for offences and civil penalties under the Corporations Act, which is a pretty big deal. And I see it as somewhere where we could start getting a lot of climate change action happening. And we're also in the early days of seeing things like shareholder actions against banks for failing to disclose climate risks. And there's been a case in Australia against a super fund for breaching fiduciary duties for failing to consider climate change as well. So even though that's not a space I'm really interested in entering into in too much detail, I think it is going to be a real space to watch for climate change action to happen. And the final box here is human rights. That's certainly where I see a lot of litigation happening in Queensland over the next few years anyway. So this table is by no means comprehensive. I think we could certainly add other boxes into it. So for example, there's a lot of criminal actions on foot against protesters in Queensland at the moment, and potentially other hypothetical causes of action that we could look at. But this is just a bit of a snapshot of where I see climate change litigation headed in the future. So as I said, the bulk of climate change litigation to date in Queensland and in Australia more broadly has taken the form of objections to decisions to approve coal mines predominantly. And we've had several pretty major cases run in Queensland over the past almost decade or so. So as I'm sure you all know, major coal mines need a number of different government approvals, and in Queensland that includes your mining lease and environmental authority. And the statutory schemes under which those authorities are granted require the decision makers to take into account a list of factors in deciding whether to provide these approvals. And these lists of factors under both statutory regimes, the Environmental Protection Act and the Mineral Resources Act, contain factors that are related to environmental protection and the environmental impacts of the project. So what litigants have done in these cases is argued that these requirements to take various environmental matters into account import an obligation to consider the Scope 3 impacts of the ultimate burning of the coal and then the ultimate impact on the environment from there. So they're not easy cases to run in that respect. And if you spell out the links in the chain of causation that litigants have to prove, they're pretty complicated. So you've got to convince a court that, you know, as a result of digging this coal out of the ground, someone else is going to burn that coal, and the first named person needs to be responsible for the actions of that second person. And those emissions are then going to cause climate change, which, as we know, we can't tie any particular particle of CO2 to any particular impact on the climate. So there have been various points at which the courts have been somewhat reluctant to follow along with those arguments. Now, the object of this type of litigation very broadly would be to have a decision set aside, so ideally to prevent a mine from going ahead. Just as a slight aside, we have a very, very odd system in Queensland that is unique within Australia and anywhere else I know, wherein the court challenge to approvals comes before the final decision is made. So the respective ministers and decision makers under the two acts make an intention to grant an approval, and anybody who made a submission during the approvals process can then ask that their submission be taken as an objection to the preliminary grant of an approval and then heard by the land court. The land court then doesn't make a judgment or a decision, it makes what's referred to as a recommendation, and then the minister makes their final decision, and they're simply required to have regard to the land court recommendation. So it's a very odd system wherein you don't get that right to challenge the final approval. The court challenge comes prior to the recommendation, which, as I said, is a unique and slightly strange feature of the Queensland system. So I've already mentioned what the barriers have been in these cases, and one of them really is the fact that we're trying to make mining companies responsible for Scope 3 emissions. And if you think about the big mines that we've had over the past few years, like the challenge to Adani, for example, we know that that coal is going to be burned overseas. So courts have struggled, I guess, to attribute responsibility to the proponent for those emissions, although we have gotten to a point where they are more willing to do that. So these are the big three cases that we've had to date, and these are just the first instance decisions. The second two have been on slightly convoluted appellate routes. But I guess the conclusion we can say on these three cases is that none of them have been successful technically. None of these have resulted in a recommendation that an approval not be granted on climate change grounds. So look, you can look at this trilogy of cases then and say they've been unsuccessful. What's the point? What would be the point in continuing? And this is a conversation I had with my colleague and friend Sean Ryan a few years ago. So he's the principal solicitor at EDO Queensland, which is now nationalised as EDO Australia. And Sean was really frustrated because he'd put years and years and years into running these cases, and he was getting lambasted in the media with suggestions that EDO were bringing vexatious claims and were wasting the court's time, that sort of thing. So Sean and I decided to systematically go through the three judgments and set out how the jurisprudence had progressed through the course of these three cases. So we came up with this following list of barriers that have been overcome. So firstly, climate change is now accepted by the Land Court, which sounds pretty obvious, but you might remember a famous case in Queensland about 15 years ago now, where the judge that was presiding over it, despite climate change science not being an issue before the parties, went and did his own very wacky research into the denialist literature and used that to influence his judgment. So it hasn't always been the case that climate science is accepted by the court, but now it is without question. We got to a point through the second case and into the third one that scope 3 emissions are now legally relevant for the decision maker to consider. So under both statutory regimes, the court is required to consider the public interest, and the courts have held that the public interest includes scope 3 emissions. So that's pretty huge. Scope 3 emissions are now relevant for the court and the decision maker to look at. Courts have held that there is cause and effect between a project's scope 3 emissions and climate change. So they've been willing to take a broad approach to causation and recognise that even though we can't tie these particular particles of CO2 to a particular climate change impact, that relationship and that causation does exist. Single projects are significant. So a lot of this really great progress has happened by using the carbon budget literature. So that literature has been used to say that, for example, Adani's mine will take up, I think, 0.5% of the global carbon budget. And that has been used to convince the courts that single projects are in fact significant on a global scale. Emissions are now assessed on a cumulative basis, which is important for things, again, like Adani, which is projected to run for 60 years. And there have been a whole lot of other interesting things that have been clarified through the course of this litigation as well. So, for example, the evidence on the black-throated finch and where it resides was clarified through the course of the litigation. It was also through the course of the litigation that Adani's job claims were found to be inflated by tenfold. So I think there is, in fact, a lot that has come out of this litigation. One of the really big remaining hurdles to succeeding in these sort of cases is the market substitution assumption, which I'm sure a lot of you are familiar with because it's used in policy a lot as well. So it's the if we don't do it, someone else will argument. And you can see how it was used by the court here in the Wandoan mine case. So it's difficult to see from the evidence that this project will cause any impact on the environment. Because the applicants say that stopping the project will have a negligible impact because other coal will be mined elsewhere, which will in turn produce the same or higher amounts of emissions when burned. And I'm sure a lot of you share my opinion that it's just extraordinary that a court can find an action like a major coal mine, like the Adani coal mine, to have no net environmental impact because if they don't do it, someone else will. But that's been accepted by all the levels of the courts here in Queensland. And as I said, I think that's quite extraordinary. I think conditions are ripening for the market substitution assumption to be overcome, and this is something that myself and my colleagues at the EDO have spent a lot of time discussing over the past few years and looking at how we can go about dismantling this assumption in the next round of litigation. And I've had another paper published this year again with Bree, my research assistant, who now works at EDO, so it's a slightly incestuous little circle there, where we came up with quite a few grounds on which the assumption can be debunked. So the economic evidence, I think, is questionable, and I'm sure a lot of you are much more familiar with economics than I am, but it seems that there is generally some sort of relationship between supply and demand, which this assumption completely overlooks. All of the cases to date have been decided pre-Paris, and I think there's a lot of information out there about the fact that meeting the Paris goals and continued reliance on coal are incompatible. So I think it might be more difficult for the court to apply this assumption into the future, particularly if you look at the fact that we're looking at mines that are likely to run for 50 to 60 years, or they're asking for approval to run for 50 to 60 years. I don't think we can say with confidence that that supply will be substituted perfectly for the next up to 60 years. So from a legal perspective, I think that raises really big evidentiary issues. I think it makes it difficult to prove it to the requisite standard that you have to do in court, which is on the balance of probabilities this will happen. I think it probably defies the precautionary principle, and although this isn't going to be quite so influential in the court, I think it's just morally and ethically wrong. So Bree and I in this paper go through and debunk the assumption and look at how we think it can be overcome. Of course, the other really important thing that happened last year that, again, some of you might be familiar with is the Rocky Hill case. That was a New South Wales case. Whoops, sorry, I just was looking at the chat to see Hugh's comment actually. Yeah, and that's exactly right here. So this is often referred to as the drug dealer's defense, which is such a misnomer because a drug dealer wouldn't be able to go to court and say, but Your Honor, if you take me off the street, someone else will deal cocaine. So on that ground, I'm not guilty. It's completely extraordinary that this is something that is accepted by the court because it makes zero sense in any other legal context. So yes, that's a good analogy here. The Rocky Hill case. So this was a decision of the New South Wales Land and Environment Court handed down a bit over a year ago now. And there was a lot of excitement about this judgment when it was handed down. Look, I was always a little bit cautious about it because the factual scenario was very different. So it was a challenge by the proponent to a refusal of approval to mine. So we were starting off with a different situation. It was a refusal. And the refusal was also based on amenity grounds. This was a mine that was very, very close to a township, which is quite different to the Galilee Basin, for example. So even though Justice Preston upheld the rejection on grounds including climate change, it's doubtful whether the climate change arguments would have been quite so strong if they were the only ones being made. But at the end of the day, Chief Justice Preston wrote this 700-paragraph judgment where probably half of it was dedicated to climate change and the climate change arguments. And he's an incredibly senior, well-respected judge who I think had been working towards this moment for 20 years, setting the groundwork and the jurisprudence before the court, where he just completely slashed the market substitution assumption, went through all sorts of evidence as to why it should not be used in courts, and concluded with this phrase that's already quite infamous, the wrong place, wrong time test, where he said that this mine would be at the wrong time because it would increase global total concentrations of greenhouse gases at a time when what is now urgently needed is a rapid and deep decrease in greenhouse gas emissions. So look, this isn't something that is binding in Queensland, but it is, I guess, post-Paris, which all of the Queensland cases rather haven't been. So it's certainly something that I think will be raised in future litigation in Queensland as a comparator at any rate. But I guess the backlash to this judgment. So Chief Justice Preston really copped it in the media over this judgment. He was accused of bias effectively. All sorts of bodies like the New South Wales Bar Association came out in his defence and said, no, he's not biased. He's a very well-respected member of the judiciary. But still, you've got to have a pretty thick skin as a judge to be willing to make one of these big, drastic decisions that completely changes the course of jurisprudence. He certainly was the man for the job. I know him quite well, and he was definitely up to the task there. But he still had to endure this fairly unpleasant media storm. So I guess in that respect, you can see why judges are quite happy to hide behind the market substitution assumption, because it is almost this get out of jail free card, that they don't really have to make this politically difficult decision. They can just say, well, this isn't going to have an environmental impact, so I can just wash my hands of it and walk away. So judicial willingness is going to be a really big step to success in one of these cases in Queensland. The other thing that happened in the wake of this case is the kind of anti-regulatory action that I mentioned before, which is that the New South Wales government introduced legislation last year to effectively neutralise the effect of this judgment and stop decision makers from considering Scope 3 emissions in deciding whether to approve coal mines. So that's the real risk as well, and the real, I guess, futility of some of these cases, that even if you do win, your success might be very short-lived. All right, I need to start talking about human rights or I'm going to run out of time. All right, so I think conditions are becoming more favourable to a successful case in Queensland. One more point I will just make before I get onto the Human Rights Act, though, is that success doesn't always come instantly in this sort of novel litigation. And Sean and I talked a lot about the tobacco litigation in the US in our 2016 article, and said that in that situation, it took decades really before plaintiffs started winning against the tobacco companies. And the same here, you do just need to be patient, and lawyers, I think, do need to be adaptive and nimble in the causes of action that they come out with. Sorry, just looking at the question that's come up, how are judges appointed in Australia? They're appointed by the government that's in power at the time. So it's not quite as political as the US system. It is supposed to be independent, but it is up to, the prevailing political party to appoint them. So not quite as bad as the US, but still not great, I think is the answer there. All right, so something incredibly important and useful that happened this year in Queensland is the commencement of the Human Rights Act. So this act was passed in 2019 and commenced in 2020. So Queensland is now one of only 3 Australian jurisdictions to have human rights legislation, and we've joined Victoria and the ACT in that respect. And the Act enshrines a number of rights that derive from instruments internationally, like the International Covenant on Civil and Political Rights. And these are the ones on screen that we've isolated as having the potential for underpinning climate change arguments. And as I said, we chose in our first article to look at the right to life for pretty obvious reasons I'll get to shortly, but there is a lot of progress happening looking at those other rights as well. So what I'm going to take you through to start with is 3 preliminary points that build upon each other to form the foundations for a right to life claim in Queensland. So firstly, in the international context, climate change has been interlinked with the right to life. So the right to life under the ICCPR has evolved over time, and the relationship between human rights and climate change is now very well recognised in international legal discourse of both human rights and climate change bodies. And one of the most recent general comments from the UN Human Rights Committee on the right to life really made some of the most wide-reaching and explicit comments to date on this relationship. And they said that environmental degradation, climate change, and unsustainable development constitute some of the most pressing and serious threats to the ability of present and future generations to enjoy the right to life. And implementation of the obligation to respect and ensure the right to life depends, inter alia, on measures taken by state parties to preserve the environment and prevent it against harm, and climate change as well. So really explicit that if states are to fulfill their duty to respect the right to life, they need to be taking action on climate change. Sorry, I've skipped through one case there. There have also been a lot of other domestic cases in other jurisdictions explicitly linking the right to life and climate change. So just briefly on the first one, the Ashgar Lagari case, this is a case from Pakistan where a citizen alleged that a failure to implement existing climate change policy offended his fundamental rights, including the right to life. And the court agreed and ordered that the government act on implementing that policy. So that's just one of a number of examples of foreign domestic judgments. So there's a clear link between climate change and human rights internationally. My next point is that the international context is relevant to interpreting the Queensland Human Rights Act, and this is actually explicitly stated in the Act. So section 48 subsection 3 says that international law and the judgments of domestic, foreign and international courts and tribunals relevant to a human right may be considered in interpreting a statutory provision. So it certainly doesn't import foreign law into Australia, but I think it is really interesting that it explicitly states in the legislation and in the explanatory notes to the legislation that what has gone on at the international level is relevant to interpreting the domestic law. And the third interlinking point is that climate change will have human health impacts in Queensland. And I probably won't go into this slide in too much detail with this audience. I suspect you are all much more across the science than I am, but there is ample scientific evidence about the many and varied human health impacts that Queenslanders are likely to be subject to under climate change. So that's the 3 preliminary points linked together. So internationally, climate change and human rights and the right to life in particular are interlinked. This international context is relevant to interpreting the Queensland Human Rights Act, and climate change will have human health impacts in Queensland. So the next thing that we then need to think about is how you can draw these points together in a meaningful way to progress climate change litigation. So this is getting into some pretty technical legal stuff. This act is procedurally incredibly complex for a legal audience, let alone a non-legal audience. So just bear with me as I go through this. The first point to make is that the Human Rights Act does several things. So what it really overwhelmingly aims to do is to create a culture of respect for human rights in Queensland. So it aims to embed human rights discourse into public decision-making. It set up the Office of the Human Rights Commissioner, and it also allows for limited rights of challenge before a court. So the important thing to note there is that the main object of the Act is not to create a regime whereby violations of human rights are widely litigated as a first port of call. So the idea is that, and this is probably a little bit naive, but the idea is that our government decision makers will start to act with a newfound respect for human rights, such that we will not need to go to the court to litigate these matters, which sounds nice, but I'm not quite sure that's going to happen. So there's all kinds of other things in the Act, like Parliament have to scrutinise legislation for its compatibility with human rights now, although incompatibility does not invalidate it necessarily, and a few other things as well. But what we're interested in today is opportunities for litigation. So the most important provisions then are sections 58 and 59. So section 58 says that it is unlawful for a public entity to act or make a decision in a way that is not compatible with human rights, or in making a decision to fail to give proper consideration to a human right. So if a public entity, like a state government decision maker, for example, makes a decision that is not compatible with human rights, then that act is unlawful. So that's stated, but it doesn't tell you what the path to challenging that unlawful decision is. To get that path, you have to look at section 59, and this is the really complicated bit. So subsection 1 says that subsection 2 applies if a person can seek any relief or remedy in relation to an act or decision on the ground that it was unlawful for another reason. And if that's the case, they can then seek relief or remedy on the ground that it's unlawful under section 58. This is called the piggyback mechanism, and what it means in a nutshell is that the only way you can basically make a claim that a decision is unlawful on the basis of non-compliance with human rights is if you have a primary cause of action that you can then piggyback that secondary cause of action on. So in this case, if you have a right under, say, the Environmental Protection Act to challenge the lawfulness of an environmental authority, then you could piggyback a claim on that the decision to grant the environmental authority was unlawful because it was not compatible with human rights. Okay, so slightly complicated procedural process. I don't think it's actually going to cause us any headaches here in Queensland though. Interestingly, this model followed the Victorian approach. So Victoria has had human rights legislation for quite a while now, and they chose to adopt this piggyback mechanism because they thought if you could just bring a primary claim on the basis of human rights, the courts would be flooded with all of these vexatious claims and it would clog up the courts. So we needed to have people having another cause of action to get in the door. What has in fact happened is that litigants have come up with fairly vexatious primary claims when their real concern is the human rights claim. So in fact, courts have had to waste an awful lot of time in Victoria looking at these fairly spurious primary claims when human rights is really the problem that they have. And the other interesting thing is you don't need to succeed on the primary claim to succeed on your human rights claim. So it's kind of odd that Queensland has adopted this model, but certainly it is what we've got. Compatible with human rights is defined within sections 8 and 13. So compatible means that it either does not limit a human right or limits it only to the extent that is reasonable and demonstrably justifiable. To determine whether something is that, then you look at the factors in section 13.2, which include the nature of the right, the nature of the purpose of the limitation, whether there are any less restrictive and reasonably available ways to achieve the purpose, and a few other things as well. So getting to the point of this slightly convoluted story, how would we frame a human rights and climate change case in Queensland? This is something that myself and environmental lawyers have been really hotly debating for the past year or two. And the really obvious way is to piggyback on that existing body of case law that I talked about earlier. So there are more mines under consideration in Queensland at the moment. So there are going to be more opportunities to challenge those approvals to coal mines. So a human rights claim can be piggybacked upon that. As I said before, I think we're getting close to success in those environmental approval cases, but that success is not a prerequisite to a successful climate change, human rights action anyway. So the human rights claim can succeed even if the primary claim fails. So what a litigant would need to argue is that a decision to approve a mine will contribute to climate change, which we can do, and we've done before in existing litigation. We could continue building on the carbon budget literature. So there's all that really great science out there that allows litigants to quantify the impact of a single mine. And we can then draw all of this together to show that a decision to approve a coal mine is incompatible with the right to life. which seems very obvious to me, but I think convincing a court is going to be more difficult for the reasons that I mentioned before. And we certainly acknowledge that. But as I said before, I think we are getting a little bit closer to convincing the Queensland judiciary of these matters. And just as an aside, I should mention the current president of our land court, Carmel McDonald, gave a talk for EDO close to 2 years ago now, where her speech, and you can access the transcript online, it's pretty extraordinary. And I think she went about as close to the line as you can get without stepping over it in terms of a blueprint for dismantling the market substitution assumption. So I think if one of these cases landed in her court, it's going to be a really good prospect of success. So if we get to a point where a court is so convinced that a decision to approve a coal mine was incompatible with human rights, there are still going to be challenges. So the government entity might then argue that this limit on human rights was either reasonable or demonstrably justifiable. So for example, they could argue that the nature of the purpose of the limitation justifies it. So there are important economic grounds for having the coal mine. Although internationally, there are some pretty strong suggestions that economic reasons are never a good reason to derogate from the right to life. So that could be argued as well. The government could also argue that there are less restrictive and reasonably available measures to achieve the goal of protecting human life from climate change in Queensland. So for example, they could point to measures to implement clean energy in Queensland and say that that's a less restrictive way of achieving the goal as opposed to banning coal mining. And as you probably gathered from my discussion of the market substitution assumption, I'm never a big fan of trading off a certain impact with an uncertain future impact, but I think that is a possibility that we need to bear in mind. Other potential barriers, look, the interpretation of the right to life. What I have pieced together in this talk is a really broad multi-link chain of causation that we need to stitch together, and you really then need to have a judge who's willing to go hand in hand with you to step through those steps to get to that end result. Queensland courts have been pretty conservative in the past, but we do have all of those really important steps that we've had through existing cases in Queensland thus far. And as I said, we do have a president of the Land Court who I think is really ready to make her mark on one of these cases. So I think that's a really interesting step to watch. Causation is going to be really challenging. So these are roughly the steps that would need to be proven to establish causation. So the Queensland government has approved an emissions intensive project. It will result in increased greenhouse gas emissions. These greenhouse gas emissions will contribute to climate change. We have made that progress thus far. But number 4, I think, is where we might stumble. So climate change will have impacts on human life in Queensland. There is ample scientific evidence of this, but again, it's still something that we're going to need judicial willingness to go along with. And finally, these impacts are not compatible with the human right to life. This is going to be really complicated, particularly in the absence of any human rights jurisprudence in Queensland, but it's certainly something that can be argued. So look, it all circles back to judicial willingness, and I acknowledge that this is an area where there really is discretion. There's no right answer. So judges really do have a choice to make, and you can see why making the politically easy choice is what they've done in the past. But I'm hoping that we're getting to a point where we might move beyond that soon. So in conclusion, climate change litigation is not going anywhere. And for as long as we continue to have no strong legislative action on climate change, environmental groups are going to continue looking to the courts for relief. Climate change litigation is a long game, so it might take many cases to get a successful result, but this successful result will be built on many, many incremental steps. So previous unsuccessful cases are therefore not to be judged as a failure. New avenues for legal challenge are continually being explored, and lawyers need to be nimble. So I never thought I was going to spend as much time as I do at the moment on human rights. But as I said, I think it is really one of the strongest avenues for climate change litigation and action more broadly in Australia at the moment. And I guess one little aside to that, coming up to the Queensland state election, I would be very, very surprised if the LNP get into power if they would look at touching this legislation, because you would have to be a very, very brave government to repeal human rights. You can mess with climate change policy, but you do not want to be the government that legislates to repeal enshrined human rights. So I think that's another really attractive thing about this act. It's something that could potentially have greater longevity than other environmental or climate change legislation. I think the Act presents enormous opportunities for climate change litigation and action. I've really just scratched the surface of that today in relation to one enshrined right, which is the right to life, and one particular avenue, which is litigation. I think looking at government policy making and decision making is something really big to look at as well. So yes, in conclusion, watch this space. I think this is going to be a really, really important area to be aware of for climate change action and progress in Queensland in the coming years. So I'll leave it there. Thank you very much.